I'm honored to be joined by Mr. Sumant Batra today with us. He is a globally renowned insolvency professional with over 30 decades of experience in insolvency and bankruptcy law. He has played an important role in the development of Indian insolvency framework. He has played a key role in the policy framework at the highest institutions such as World Bank and IMF, and as well as he has been an accomplished author who has written across genres, wearing multiple hats. Now he brings his unmatched expertise with his book Corporate Insolvency: Road to Viksit Bharat. We aim to this conversation with him nothing less than a masterclass, that is Corporate Insolvency. His book, that is an authoritative book, Corporate Insolvency: The Road to Viksit Bharat, as has been aptly described by Mr. Sanjeev Sanyal, it's the institutional memory of the entire system. We aim for this conversation to be nothing short of a masterclass. Mr. Batra, thank you for joining us here today.
Simran, thank you so much for talking to me.
So the intention behind this conversation is for the legal professionals, young professionals for that matter, young economists, academicians, and business leaders to actually get the better understanding of the corporate insolvency world, and not just the legal framework, but also to understand the economic nuances of it. So, on that background, I would just like to start with a very simple question here. What is insolvency in everyday terms? And if you had to explain it with an analogy, how would you describe it?
A very good question, Simran, because often insolvency is understood as a very complex, sophisticated subject, which it is indeed. Right. And it takes years for people to be able to get a grip of the subject, both the economists, the lawyers, the scholars. At the same point of time, surprisingly, insolvency is something which is quite basic in terms of what it really means and how it is understood or ought to be understood in common parlance by people who do not really need to understand insolvency as a specialized subject. But before I answer your question, I also picked up what you also mentioned, and I think I'd like to sort of also respond to that it is understood as something which operates in the realm of economy. Yeah. And of course, as a law, in the realm of legal field. But it also has a great connotation in cultural and social context. And I will attempt to cover all that in my response to your question. So anybody would understand insolvency to mean someone who's gone bankrupt, which means that someone who doesn't have the money to pay the debts, and therefore people say, he's gone bankrupt. That's a very simple meaning, but often oversimplified. Insolvency has no meaning without it being read as something which then has a prefix to that and a suffix to that. Simply stating, something which deals with the situations, circumstances, reasons that leads you to a situation where you're not able to pay the debt. And then as a suffix, it sort of talks about the law, insolvency law or insolvency process, where you talk of or deal with situations where that person or an entity which is or who is unable to pay the debt has to come out of the way of that distress or inability to pay the debt. This, in a way, combined together is what simply stating insolvency is. You asked me to give an analogy. Now that analogy which I'm going to give, also is very simple. It is like entering a cinema hall, right? When you go to a cinema hall, you see that you're made to enter through a particular door. But when you get inside the hall and it's completely dark, you see signs on the floor which are directing you to the exit door, which are also neon lit. That these are the exit doors, which means that in the event of a fire or any other situation of crisis, the cinema hall owner or manager is telling you that you need to exit through those doors. You need to exit them through those doors even otherwise. But they also from the floor direct you that this is the passage that you need to take to the exit floor, which means that the message is that your exit should be orderly, not chaotic. You should not end up hurting one another. In fact, you should cooperate with each other when you exit. Right? Now, let us just contextualize it with the insolvency law, which is where the complexities come in, and make the insolvency law sophisticated with nuances like no other law. Now, when a person goes insolvent or a corporate entity goes insolvent, then what the insolvency law requires, sometimes more specifically, sometimes in an unsaid way, to investigate, understand, explore the reasons why that situation of insolvency occurred, which is what led to the circumstances that the person or entity is unable to pay the debts. And that's a very important and critical aspect of an insolvency law. And I'll talk about that later on because I don't want to sort of digress from the question that you asked about what insolvency is. Now, when the person has entered into the stage of insolvency or a corporate entity has entered into the stage of insolvency, this is where insolvency as a law, as a process, as a principle, as a philosophy comes in. I'll talk about the philosophy, which I mentioned about the cultural and social aspect, then I'll come to the economic and the legal aspect, which is what collectively provides a meaning to the insolvency as a word, as a concept. So, somebody goes insolvent as a person or as a corporate entity in which there are hundreds of people working as people who have jobs there at different levels of that enterprise. They're all part of this society. They all live in a society as part of the social fabric of that society. They have families, they have children who go to school, who are going through education. They are people who are also those who want to live with dignity, who don't want to be ridiculed, who are also in many, many ways giving the character to this society because of their behavior, whether you live in happiness or whether you live in peace. And therefore, it is important that in the treatment of their insolvency, you keep in mind that the social order is not disturbed. I'm talking of that now, and giving the analogy of the cinema hall example. So you want to make sure that everything that happens in the treatment of that person's insolvency does not disturb the social and cultural aspect also, which is associated with the dignity, with how people understand, are humiliated, or are they feeling in any manner shortchanged by the society just because that person is not able to pay the debt. Not being able to pay the debt is not a crime. Then let's talk about the economic aspect. Now, if you're an enterprise or a person himself or herself goes into insolvency, not able to pay the debt, but has been indulging in some economic activity, running a mom and pop shop, running a small business, let's say a workshop of a car mechanic. He's individual, working hard with 5 employees, but the fact remains that he is doing an economic activity. Let's say he borrowed 5 lakh rupees to buy more tools, maybe a machinery, for car wash, right, where you elevate the car to a level where you can start washing it from beneath. He borrowed, let's say, 5 to 10 lakh rupees for that. And he's not able to pay the debt because, let's say, for some reason, there was a curfew in the city, there were riots, or there was some other reason because of it, there was no cars coming to his workshop, and he's not able to pay the debt to the banks. Now, the fact remains that that gentleman was providing employment to 5-6 people. He was indulging in an economic activity, which means that he would, in order to service the car, get oil, get gear oil, brake oil, somebody will buy from, etc., etc. All this part of economic activity. So he's contributing to the economic activity. Where there's a workshop, there'll be a tea stall because somebody who's waiting there for the employees to have tea. There'll be a small dhaba somewhere close by. So this, where the customer will go and probably have a cup of tea or a food while they're waiting for the car to be serviced. So he's contributing to the economy of his immediate surrounding. And depending on the scale of the business, from a workshop to a slightly bigger business, your expanse of economic contribution widens and broadens. And you don't want that when an insolvency happens, that economic disruption takes place because it impacts other people. It impacts your immediate surrounding where you're doing that economic activity. And then there is the law. Or before I go to the law, even on the economic activity. So supposedly you're talking of multiple enterprises that go into distress. Their impact to the economy would be significant.
Right.
And if it is a multinational organization, which is a big corporate doing multiple things, employing 1,000, 2,000, 5,000, 10,000 people, just imagine the kind of impact that companies going bust has on the economy. Now, this is where the law steps in. When I gave you the example of cinema hall, I gave you the example of exit signs, the signage on the floor, something which the one of the crew members when you board a flight and it's about to take off, the first thing they tell you is that in the event of distress, the oxygen mask will fall. You bend like this, and you attend to yourself first, then to the children that may be accompanying you. She points to the exit doors. She points to the entire. This is how you have to follow. This is exactly what the insolvency law does. Insolvency law now provides you the mechanics of an orderly exit for people, enterprises in distress. What it does is it, in the letter of law, provides the rules. It also provides the policy in a way before that, or at least is expressed and articulated in the law as to how a particular nation seeks to provide that orderly mechanism. And that's where the insolvency law comes in. But in a more sophisticated way, the insolvency law, as it is understood by those who have spent decades formulating the policy, framing laws, legislations, practicing. For us, it has a slightly more nuanced meaning, which is what graduates it from the elementary meaning to its most sophisticated expression, which is that the insolvency law policy helps transfer distressed enterprises and its assets, which were in the hands of managers who were not capable of managing it well, or could not manage it well, not just because of their incompetence or inability, but because of various other factors, the insolvency law facilitates the transfer of these assets and enterprises to a new set of hands, which would be more capable or able to manage those assets, or would be better positioned so that those assets and enterprises can be put to best use, their more or most optimum use, and eventually contribute to the economy of the nation, economic growth of the nation, the GDP of the nation, and therefore collectively all these assets don't become non-performing or don't stay non-performing, but become performing and are out there in the economy contributing to nation's growth. So from a simple meaning to its most sophisticated meaning is what insolvency is about. I'm sorry for a rather longish answer, but I think this is what my understanding of insolvency
But I really like how you have given it a larger perspective. So when we look at insolvency, like from an outsider's or public point of view, you look at it as if there is an A company. That company is unable to pay debt. They are distressed. But you have wonderfully described it. It's not just how it impacts economy, but there is a social fabric also which plays a very big role in it. So I have this one question. So like you mentioned in your analogy that there is always an exit, orderly exit. So insolvency, when it shows you the door towards exit, can we say those doors open to another entry? Because it's said to be your rebirth or second chance through life, and instead of a death in real terms of the company or the debtor.
Yeah. So that's actually, Simran, a very good perspective of it. And in fact, you sort of leading the conversation to something which what we call as policy choices in insolvency, which is that does that exit door actually lead to what is a death knell, which is where that's the end of the company, shutters go down, and exit really means not just exit, it means burning the company, right? Or the policy choice means that exit door in fact is the door to another world, a second chance, next life, whatever you may call it, which means that it really stays alive, but in a different avatar. Right? Yeah. And in the example that I gave, the eventually how we understand insolvency has shades of both. And I'll explain that in a moment because you asked that question. So the policy choice now in a more sophisticated way means when you enter the exit door, because you're not actually exiting only, you're entering the exit door. Who makes the decision that from exit door it is now end of the world or it is enter another chance? And what are the factors that help you decide what should be the choice? That exactly is the most complex but interesting aspects of insolvency law, which many economies have not yet fully comprehended. And it took India also fairly long time to be able to do that. But in simple terms, what it really means that at that point in time, your lenders and the state of the economy state of the economy of the country determines what is it that you must do with that asset or that enterprise or with that insolvency. In the context of corporate insolvency, it is the set of lenders who have some control on that company because of the fact that they've given loans to the company because of the fact that they have security interest over the assets of the company, they decide whether it'll be okay to give second chance or whether we should just call it a day. And that decision will be determined by the fact as to in what of the two options would they be able to maximize the value of the assets, to maximize the return for themselves and for the other stakeholders. That is the driving decision, driving factor, the most underlying factor, which in fact depends on the philosophy of the nation also, because historically, once an insolvent, you were looked at with a great amount of stigma. It was almost like a capital punishment. I'm talking about centuries back. But over a period of time, as human became more refined, civilized, sophisticated, they learned of the choices and the alternatives, and also sometimes because of the compulsions of the economy. But to come back to the question, it is therefore, one decides whether you should, for the corporate enterprise, give it a chance of revival, second chance, or you should liquidate it, right? Yeah. So therefore the policy of liquidation or restructuring, revival, rehabilitation, whatever you may call it. There are many words for this. For an individual, it is whether you should give him a second chance or whether you should declare him a bankrupt, which means that he can't come around. There's no way that you can give him a second chance. It doesn't, the circumstances don't exist, assets don't exist, or the lenders don't really think that he deserves a second chance. Or sometimes the policy doesn't allow you to give a second chance. And that's when the person becomes bankrupt.
So that you have now wonderfully explained, because usually people, what they do is insolvency and bankruptcy is used interchangeably. And then the word restructuring is just used in the mix. So what I have gathered, and correct me if I've understood it rightly. So insolvency, then the doors which it leads to for a company which has to pay a debt, it could lead to insolvency, restructuring, or bankruptcy. These are three different doors and they cannot be used interchangeably. They do not mean one and the same thing, right?
Again, I'm very glad that you asked that question, because one of the most fundamental issues that nobody really talks about as much because it's so elementary.
Yeah. But still we end up making mistakes.
Well, I'm not sure about the mistakes, but the fact remains that you need to at least have clarity on what is insolvency, what is bankruptcy, what is revival, rehabilitation, restructuring, second chance. Are they same, different? And if they're different, how different? And that's where the sophistication comes in. That is why insolvency becomes what we people say as a very complex subject. But as a nomenclature, it is, as you rightly mentioned, interchangeably used. You see, there are countries which don't even use the word insolvency. For them, it's bankruptcy law. Then there are those that use only insolvency. They don't even use bankruptcy as a word. Then there are those, like in India, where we use both insolvency and bankruptcy. Right. And then there are those that use neither insolvency or bankruptcy, but they use different kind of words. Now, that's a policy choice. Whatever word you make use of, it is how you provide the treatment to that word actually decides what is it that you're using that word for. And the word itself has no meaning. So if you pick up insolvency and bankruptcy code, the word insolvency is not defined. The word bankruptcy is also not defined, because mostly worldwide, insolvency doesn't really have a set meaning in law. As we were discussing, it is an expression of social, cultural, economic, legal to some extent, but there is no compartmentalized definition of insolvency or bankruptcy. And that is why it has been used with a degree of flexibility. But allow me to share with you how we use it in India and how in some other jurisdictions it has been used. in the context of India, we use insolvency as far as the word for the corporate persons or entities. It means you are in a state where it is clear that you have defaulted, you are not able to pay your debt, and now we will explore whether as a corporate entity you can be revived and can come out with, let's say, flying colors. And in the context of individual, whether you are in a position to, we will explore whether a repayment plan to the lenders is possible. Because there can't be a restructuring of an individual. So the whole idea is, are you in a position to repay your debt in a way which is acceptable to the lenders at large, and attempt it in a way which is dignified, so that you don't go bankrupt. Now, if I were to continue, therefore, bankruptcy then is a stage where you've explored all possibilities of that person being able to pay the repayment plan in a manner acceptable to the creditors, but it is leaving to nowhere, and therefore you then have to provide a treatment, and that treatment is bankruptcy, which means that that person is not able to pay his debt by way of a repayment plan, and you are now saying that you are bankrupt. So you create a distinction between insolvency and bankrupt. And bankrupt therefore means that you are a person who is declared by law as someone who has not been able to pay the debts that you borrowed. Right? For corporate insolvency, the word used is not bankrupt. It is liquidation, which doesn't feature in the title of the law, right? Insolvency and bankruptcy. And I wonder why. Because, then you also talk about, insolvency, the resolution of the individual, or you talk about the liquidation also. But the fact remains that yes. So if you now see the same process for the insolvency of the enterprise, there you explore whether that enterprise can be revived, can be brought back into the society as we were just discussing. And if not, then pull the shutters down on that enterprise, which is liquidation. So liquidation is the door, one of the two doors that we discussed, where it leads to your signing the death certificate in a way.
Right. So insolvency is my second chance to life. Liquidation is my death.
Yes, liquidation of the corporate entity is a death. For a bankrupt, it is like you being imposed with many restrictions going forward till such time that bankruptcy operates, which operates for a particular period of time. And of course, when we talk about the individual insolvency, we can talk about that. But for an individual, as long as that bankruptcy operates, you can't borrow. Nobody will give you a loan again.
Right.
And there are such other similar kind of restrictions that are imposed by the law, which are distinct from a liquidation, but are those that will create certain obstacles or obstructions or hurdles in your normal economic life. So it's a more mellowed down kind of thing.
Now, after understanding this basic terms, I think it would be easier to now understand. Now, before the IBC came into picture, companies often relied on government bailouts. So how would just walk us through did we move from that to having IBC today as a law?
Then finish your question.
No, so, and then how these terms which we have understood, insolvency, bankruptcy, liquidation, and they actually materialized and become systemized.
Okay, so first of all, Simran, that would require a very rather long answer, but I'm happy to provide that because you're trying to cover, as far as India is concerned, a journey of almost 75 years. And in fact, much longer. If we start talking about the bailout, as to how the bailout has a history associated with India. But I'll try to do it in a as compressed and yet meaningful way. But it is not just the bailout. Bailout is more typical in the context of India, but not necessarily a phenomena that is associated with insolvency. That was somewhat unique to India, and it's unique to many other countries, particularly in the global south. But not as much in the free market economies. So, when in 1947 India became independent, we had policy choices. I mean the government of the time. And they decided that given the economic state of affairs, given our societal stage, the British had left India, the state would have to proactively play a role in building the economy. The reason for that was that economy was in shambles. Our GDP was down to 1%. From being one of the fastest growing economies in the world, or most prosperous country in the world, or region in the world, 200, 300, 4 years ago, before the advent of the Islamic invaders who started obviously taking a lot of our wealth out of the country. Then, of course, there was stabilization to some extent, when the later part of Timurids, who we call as Mughals, after Akbar decided to stay here and, make Hindustan their home. So the exodus of wealth stopped. But the fact remains that it still was the wealth of individuals who ruled the country and not of the nation. And therefore, the British came. When the British came, the East India Company first before them. The East India Company, the only thing it did was that it sort of drained India of its wealth systematically. And so did, of course, the British when they formally took over from East India Company to rule India as a colony. And they left us in a very bad state. All the industries had been shut because most of the industries that they operated were those that exported to British colonies and to UK itself. And there was poverty. There was a huge amount of distress. And it was at that point of time that Jawaharlal Nehru's government, our first Prime Minister of independent India, they decided that we need to have an economy that is built by the state. So a lot of public sector banks was set up. A lot of public sector enterprises were set up. And they're the ones who started building the new India. Massive effort. Private enterprises were in the hands of select few. So we all know whether it's the Tatas or the Modis of that time, to Birlas, to Godrej, big houses, but they were given very controlled kind of role in the economy. There was license raj. You had to take license for everything. And it was very regulated because the state wanted that they should build India as per the vision of people of those times in governance. Fair enough. But what really happens, Simran, that as people of a country, we all are aspirants. We are all, we probably live, breathe quite different from how the state wants us to. We have our own dreams. Our state wants that we'll have India Tourism Development Corporation, which will own hotels all over the country, which is how it started. or the Tatas obviously started the Taj. They were already into hotel business. And you had Taj Gateway in Bombay, which, existed even before independence. But there were so many other Indians who wanted to set up hotels. I'm giving you an example. But it was so difficult to do that because, one, the banks won't really give loan to everybody and anybody. It was quite difficult. Getting licenses to operate hotels was different because state had so much of regulation and control. We had the MRTP Act, etc., etc. There was a huge list on which only of businesses where only state could undertake a business, private people could not. Which means there was no competition. But state itself, when it gets into doing business, it doesn't necessarily know how to do business because that's an enterprising skill. So, obviously, these enterprises started facing problems, the state-owned enterprises. And they were not raising capital from the market. They were either borrowing from the public sector banks or the government was putting its own money. And whenever that enterprise went into difficulty, the government will put in more money or the banks will give more loan, which is what we understand as a bailout. Okay. They would never let that enterprise fail. Now, in a capitalist market, or even in a free market economy, failure is a very natural phenomenon. Business, enterprising, people, entrepreneurs try their luck at different businesses. They succeed or fail. It is very well understood that failures do happen. But in our case, there was no room for failure. Nobody was allowed to fail because we could not afford failure. There was competition and so many lives, economy, everything dependent on those few enterprises. So the concept of bailout started. And this became a culture. It was in the 1980s when, for the first time, we had a rethinking on this when Sikh Industrial Companies Special Provisions Act was introduced. I think it was in 1985. That was the time when Mr. Rajiv Gandhi was the Prime Minister. Young fellow. He had his own vision for the country and he had taken over as Prime Minister after Indira Gandhi was assassinated in 1984, his mother, then Prime Minister. And, he was someone who was foreign educated, young, aspirational. So he brought in many changes in the telecom sector and other sectors. He reduced the age of voting age for the children, for the young to 18. And one of the factors he paid attention to was on the economic side, brought in this law. But the difficulty was that this law was inspired from the US Chapter 11 law. US Chapter 11 insolvency is a free market economy animal. Right. But we were still in a closed economy environment. So it didn't really work. And it was what I call it as a poor man's version of Chapter 11. And we didn't really have a plan for its implementation for some reason. And therefore, it didn't really take off in a big way. Rather, it was misused. And it continued to be misused because what it did was it granted opportunity for businesses to seek restructuring by approaching a forum called Board for Industrial and Financial Reconstruction that was set up under that law, which we call as IICA for short. And the moment you filed that application, it triggered what we called as the infamous Section 22 moratorium, which means that nobody could touch you, nobody could take legal action against you. So it's insulated you from all kinds of legal actions. So the promoters were misusing it. The winding up was under the Companies Act of 1956. It was also very long drawn process because it was handled by the High Court then, and every High Court had designated a court as a company court, but they would sit only for half a day or 1 day in a week. And it sort of created a backlog, work piled up, and it took about 8 to 10 years for the company to be liquidated. And there were delays, huge. So we had the IICA problem, we had the delays in the liquidation.
So law was fragmented, that would say.
Yeah, so law was also, had started getting fragmented at that stage. But it is sort of now, I'm talking about what we're talking about, the to exit to where it lead to. So we had opened a door for revival through IICA, because earlier it was only liquidation.
Right.
You could do amalgamation and schemes and mergers, but there was no insolvency policy. So liquidation took 10 years, and Sikh Industrial Companies Act, which was the revival door, was being abused. There was nothing really happening. So there were frustrations. Now, as you mentioned, the fragmentation. In the 1990s, the Debt Recovery Tribunal Act came in, because the banks were very frustrated. SICA was not working, winding up, they were not able to recover monies for years. And then the government said, okay, let's have Debt Recovery Tribunal Act, where they set up debt recovery tribunals. But unfortunately, that also didn't really work for reasons that we all know. It is well documented. I don't want to really talk too much about that. And another fragmentation happened when we had the SCC Act, the Securitization and Reconstruction of Financial Assets. Now, the genesis of that was the Asian financial crisis, where, in 1998, we had the Asian financial crisis. And although India was insulated a little bit, because we were still not an economy that was globally integrated fully, as we are now, but there was a lot of pressure from the investors and otherwise to modernize our insolvency law. So as a step towards that, asset reconstruction companies were planned to be set up. That was again a nomenclature or let's say an idea or a concept that came up from as an Asian financial crisis, because when in Indonesia in 1997 late, the Asia Pulp and Paper Corporation, which was a global corporation, went bust. It impacted Southeast Asian economies, Malaysia, Thailand, Indonesia, to some extent Singapore, Thailand. And all of them actually set up asset reconstruction companies where all the non-performing loans of the banks were transferred in order to sort of free up the banks of their loaded balance sheets of bad assets. And for asset reconstruction companies, which could then buy distressed assets from the banks and pay some consideration for that, so that the banks are not really burdened with the non-performing assets. So you had now the winding up under the Companies Act, you had SICA, you had DRT Act, and then now you had SCC as well. Around the same time, the Reserve Bank of India came up with the corporate debt restructuring scheme. Because what had happened was that a few years ago, in late 90s, the United Kingdom's central bank came up with a policy called the London approach. Later on, INSOL International came up with this INSOL global principles, which dealt with some element of restructuring where more than one bank was involved. And India adopted that in the form of CDR, which was what we know as informal insolvency. So for the first time, we now, because of the frustrations in the formal insolvency frameworks, we had an insolvency framework that was informal, where you didn't need to go to court. The banks did it contractually, which also had its own weaknesses because it was not binding. You could not enforce it because it was voluntary. So anybody who turned a rebel or didn't want to cooperate, the scheme won't work. So therefore, you had all these various laws operating, none of them were functional. Now, in 1999, IRADI committee was set up for the first time by the government to undertake comprehensive insolvency reforms. IRADI committee recommended for the first time that we should have separate bankruptcy tribunals. They also proposed that there should be specialized insolvency profession. They also suggested that we should marry the Sikh Industrial Companies Act with the Companies Act. We should repeal SICA and bring it, transport, whatever you may call it, into the Companies Act. They also suggested the Company Law Board should be abolished, which was to do with the restructuring as a part of the scheme under the Companies Act, and which was another thing that was operating in parallel for revival. Irani Committee recommendations eventually gave shape to Companies Second Amendment Act of 2001 or 2. I'm not able to recollect exactly. And National Company Law Tribunal was proposed. National Company Law Tribunals were, as an idea or as a concept in the Companies Act, was challenged by Madras High Court Bar Association in the Madras High Court. While that challenge was being heard for some years, they had stayed that, the High Court, because they said that it is not prima facie meeting the constitutional requirements. In the meantime, Irani Committee was set up by the government. This was UPA 1 government under Dr. Manmohan Singh. That was the time when the world had moved with speed on the insolvency reform. A huge amounts of development had already taken place, and I was deeply associated with most of it, as you graciously mentioned in the introduction, with the IMF, with the World Bank, and otherwise. So at that point in time, I met Mr. Premchand Gupta, I recall, was the cabinet minister holding Corporate Affairs Ministry portfolio. For the first time, Corporate Affairs Ministry had been branched out of the Finance Ministry. It was till then a department of the Ministry of Finance, and he had become the minister. I met him. He was from one of the alliance partners of Congress at that time in UK. He was from RJD, Mr. Lalu Prasad's party. So which was then, I think, a different party, named differently. So I met him and I told him that you need to do something about insolvency, because what has been proposed as a part of the company's Second Amendment of 2001 is not really something that is going to serve any purpose. It's already outdated by 10 to 15 years. So he being a businessman himself, felt that there was a point in what I was saying, but he was very concerned also because the Parliament had just passed the bill. How would you then again go back to the Parliament and start talking of change? They would say, what were you doing when the bill was being tabled? But he said that you have to convince the Prime Minister for this. So he arranged a meeting with Dr. Manmohan Singh, and Dr. Manmohan Singh, he was a well-known economist, very highly regarded, and served in IMF. So gave me about 10 minutes, and he spoke very little, as you know. He was known to speak very little, very few, a man of few words. He said only two things, or three maybe. When I had spoken to him about a few things, he said, Mr. Batra, in his usual style, even the ink has not dried on the Companies Act, Amendment Act of 2001, and you want us to, go back to the drawing board again. So I very humbly requested us this because of these reasons that I proposed to him. And then he nodded and he said to the minister, "Okay, go ahead." So the minister then, directed the secretary in the ministry to tweak the terms, or the terms of reference of the Irani Committee, and also include the insolvency law review as a part of that. Otherwise, the Irani Committee was set up only to review the Companies Act to make ease of doing business, more stronger. That is how. So that is how I got into then, for the first time, as a formal opportunity to roll up my sleeves, work with the government, and thrash out a modern insolvency law, which we did. And I'm so glad that everybody in the committee, including Shardul, was on that committee. Dr. J.J. Rani was a great chairman. We had Jitesh Khosla from the Ministry of Corporate Affairs, then joint secretary on that committee. We debated for about 4 months, ultimately gave recommendations on our report. And then Jitesh Khosla and I got down to writing the law. the insolvency part, which went a little back and forth. At that time also, the government was being supported by left parties. And there were certain things that, we were aware that politically left will not agree to, because they were always opposed to diluting the public sector and going too capitalist. They were always opposing India's liberalization policy. So, you had to negotiate your way through. So, but having said that, we were able to sort of propose something that was very interesting and eventually was tabled in the parliament as a bill, Second Amendment bill. And that was the time when Satyam fraud happened, and which of course captured the imagination of everybody in a wrong way, in a different way, in a way that it sort of brought out so many loopholes in our governance system, corporate governance system, transparency system, accountability system, and the parliament, the joint parliamentary committee that was set up to sort of investigate that Satyam fraud. Although in Satyam, one of the classic examples also was that the government acted in such a brilliant way in order to save the enterprise. The board was replaced and everything. But that's a different story on how we saved an enterprise. But coming back to the insolvency law, JPC then referred the bill back to the ministry to say, you will revisit the corporate governance parts, make it more stronger. Collaterally, insolvency laws, being a part of the Companies Act, went back to the government. In the meantime, we were able to present it back. But then UPA's first term ended and the bill lapsed. If the bill is not passed in the term, then it is deemed to have lapsed. And you have to represent it or it sort of goes away. UPA too came back to power again, but this time, it was not as effective a government as we all know from history. The bill was tabled again, but it never got the attention because there were so many disruptions, there were so many other aspects that it never really came for discussion. Finally, it did. Just before the general election, and it was passed also before Modi took over as Prime Minister. Modi took over as the Prime Minister. It was passed. The Companies Act part of it, 2013, certain provisions were notified by the government and to give effect to. National Company Law Tribunal was part of it. In the meantime, the Madras High Court had told the government that we don't agree with the National Company Law Tribunal certain procedures of selection of members. This was happening all this time, from 2001 to 2013. And the matter had gone up to Supreme Court. The government went to the Supreme Court to challenge the decision of the Madras High Court Bar Association. The Madras High Court Bar Association also went to the Supreme Court. They were dissatisfied. And the Supreme Court also gave a judgment. The Parliament amended the provisions of the National Company Law Tribunal to satisfy the Supreme Court. Those were also challenged. But ultimately, Supreme Court had by now said, with these changes, if you make, we are okay with the National Company Law Tribunal. So that had been done. So National Company Law Tribunal was now a living animal, but still had not been unleashed into the market. And we had government trying to sort of, the grants and everything were coming up, the whole planning of how many employees, how many members, everything was happening. So while this was happening, 2013 Act came in. But the government decided not to operationalize the insolvency part of it for whatever reasons. I mean, I'm aware of some, but I don't want to comment here on that. The only comment that I'll make is that part of the law, if you see sitting on the bill, was designed for 40 years ahead. I'm not saying it to sort of pat my back, but it was very futuristic. And we were aware, that's the best that the India could ever get. And of course, we know that what we got was 2014, which is also brilliant, is brilliant. But many of the things that you see now getting introduced 10 years later is something that was already there in what we had done in 2009, 2010. Because we knew it's inevitable. But for whatever reason, I'm coming back now to 2014, because you asked how did we end up there. I'm very close to now the tail end of that entire journey. We saw the government for the first time in 20-30 years. We had a government with an absolute majority, a very strong government representing the will of the people. But the focus still was on fulfilling the promises, various political promises that had been given. But of course, one of the most important things that the government had to do at that point of time was to revive the economy. Because our economy until about 8 to 10 years ago back was growing at 12, 11, 10%. It had touched 10%. One I think quarter it even touched 11.5 something. But it had been dropping since then. And I think it was down to about 4 or 5% at the time when Prime Minister Modi took over. The banking sector was in a major crisis. The NPLs had grown to an alarming level, to an extent where the market failure was almost inevitable. The banks had no capitalization, they had no money to start lending. And lending is the most important activity for economic growth. There were also problems of ever greening the loans and the balance sheets, what we call as twin balance sheet problem, which I'll talk about at some point in time later. But we had so many problems which were necessary to be corrected for economic growth to start. It was around this time, immediately after taking over as the Prime Minister Modi went to US. That was his, I think, first trip abroad after taking over as Prime Minister, where he met IMF, World Bank, major investors, global investment companies, who all he invited to invest in India. And he said, we have a majority government. We are determined to make India's story a great success again. Come and invest in India. And I'm told, I was not there, but many people, that all of them said, we believe in India's story. We want to come to India. But where is the exit law? You are showing us the entry law. But where is the exit law? And for any investor to make an investment decision, not just the entry law matters, but an exit law also matters.
Carries equal importance.
So when he came back to India, he asked Mr. Arun Jaitley, late Arun Jaitley, who was then a finance minister, to take this up on priority. And immediately Bankruptcy Law Reforms Committee was set up. Bankruptcy Law Reforms Committee was given a very strict timelines to propose the law and even draft one. Mr. T.K. Vishwanathan, who had earlier been the law secretary, or perhaps he still was at that time, he was a member of the Law Commission at some point in time. Very well versed with this law because I had interacted with him on many occasions earlier. Great team put together as members of the committee. And that committee, in November 2015, gave its interim report, conceptualizing the principles based on a very modern free market economy law, and then presented his final report in early 2016, and it was tabled in the parliament, referred to the Joint Parliamentary Committee, chaired by Shri Bhupender Yadav, who is currently Environment and Climate Change Minister, but that time I think I'm not too sure he held a cabinet position, but a very senior member of parliament and a very eminent lawyer as well. And they made certain recommendations. The bill was tabled in the parliament, cleared in May 2016, notified by the President of India, and we had something that is called an Insolvency and Bankruptcy Code 2016. After a long journey, very turbulent journey, a law that has made history. So that is the bailout to this. Only one thing that I want to mention, although this is something which the readers must read in my book, is I mentioned in the whole thing about the bailouts. One of the most interesting classic case of bailout of East India Company. That was the first corporate bailout in the world. And that, incidentally, although of course East India Company was a UK company, but East India Company is that paved the way for Britishers to take India up as a colony, rule India. And that East India Company, because of its historical association with India and how it sort of operated in India, and how the owners, shareholders of East India Company drained India of its wealth, and also East India Company itself therefore became insolvent, was bailed out a couple of times by the Queen of England at that point in time, but eventually had to be liquidated. And I've devoted, I think, one chapter, or if not a substantial part of one chapter, on showing that how even the first mega, or the only first corporate bailout that happened was of East India Company, which also had roots in India in a way. So that's what the journey of, from an antiquated insolvency system to our efforts to make it more modern, to eventually, IBC coming into play, is the long journey of Indian insolvency law from 1947 till date.
So certainly it was unprecedented how the IBC was rolled out. Now, considering the journey of IBC becoming what it is today was not so simple, so IBC itself as a process is also not so simple. It's the whole ecosystem of interaction of different players: resolution, professional, COC, debtors, creditors. So if you could just walk us through how all these players interact with each other, maybe with an example or a story, it's just easier to understand.
Well, Simran, I think before we get down to discussing how they operate and make an insolvency system happen, maybe we need to step back a little bit, and I need to share who are these stakeholders, right, and how are they positioned in the IBC, and maybe give a little bit of introduction to IBC, although of course people know what IBC is all about. But in that introduction, then sort of mention a little bit about who these players are, and then we could get down to how they operate, and maybe that's something which we could do as a part of actually when we start discussing how when IBC rolls out, and give you an example of a case, or the first few cases, and as to how then they play a role. But I'll just tell you a broad framework of. So
what you
IBC.
Can do is, if you can explain it in one word, if you do it in let's say if I give you the word as simple as who's debtor.
Yeah, sure. So that's exactly how I'm proposed to do. So now the Insolvency and Bankruptcy Code actually is something that consolidated all the other fragmented laws. It's sort of provided the framework for both the resolution and liquidation as far as corporates are concerned, and for individuals, the insolvency and the bankruptcy. So when you consolidate, therefore, what you do is all the stakeholders also come in. So what IBC provides is that if you're in an event of if you have defaulted in the payment of debt as a debtor, or as a creditor whose loan has been defaulted by a debtor, both of them can approach National Company Law Tribunal, but not acting as NCLT, but as adjudicating under the authority under the law, and seek exploration of the revival. Revival is explored, and in the event revival doesn't work, you're liquidated. So in the length and breadth of this process, there are many institutions and many stakeholders. There are 4 kind of institutions. The first is the adjudicating authority itself. So this is what we call as the bankruptcy tribunal. So bankruptcy tribunals have been set up. NCLT has been designated as the bankruptcy tribunal, and their role is to supervise the insolvency process to a degree that is provided, and also eventually sign off the plan which says it can be revived. I'm simplifying it at the moment. So you have the adjudicating authority. Then you have the Insolvency and Bankruptcy Board, which is a regulator that has been set up, which has been given 2 responsibilities. The first responsibility is to regulate the process of insolvency resolution and even liquidation, if it is so ordered for an enterprise. And this is a very unique regulator. We'll talk about that later. The third institution that has been set up is insolvency profession. I call it as an institution because it sort of creates a new discipline, new profession called insolvency professionals. Their role is to act as managers of this process of resolution or liquidators. They are the ones who make the process happen. And the fourth institution is what we call as information utility, which is like a registry system where all the lenders are expected and even debtors are expected to register their loans, etc., for the purpose of identifying the defaults. So 4 institutions. Now the stakeholders which are part of or as a drop down of these. One is the debtor itself. That debtor is the one who has borrowed loan. A debtor can also be a defaulter. Then there is a creditor. The creditor is the one from whom the debtor may have borrowed. There can be more than one creditors or creditor. Then there is the insolvency profession. Then there is adjudicating authority, which is a big stakeholder. Then there is a regulator. Then there are other players who may not be associated with these 4, but are part of the ecosystem. For example, valuers. And I'll explain later on that valuers play a very important role because they help in identifying or determining the value of the distressed enterprise, basis which resolutions are taken. Then there are companies that come forward to help in revival. They call it as resolution applicants. They're the ones who then put in a resolution plan to help the distressed enterprise come out of the insolvency. Or there can be other companies who buy the assets if the company is ordered to be liquidation. So when there's no revival, but somebody has to buy the assets so that the company can be freed up of its assets, and the company itself, just as a name, as a registered enterprise, is signed off from the registrar of companies. And then, of course, there are other stakeholders like the government, because they make policy. There are other big or small enterprise like the corporate entities, not asset reconstruction companies, non-banking finance companies. Then there is the Reserve Bank of India, which sort of supervises certain part of regulation of certain entities. It's a bunch of stakeholders as a part of the institution or as a part of the ecosystem that constitute the Insolvency and Bankruptcy Code. And the adjudicating authority, NCLT was designated as adjudicating authority from 1st June 2016. 1st October 2016, Insolvency and Bankruptcy Board of India came into being. Insolvency professionals had in the meantime started getting licensed from 1st October. 1st December 2016, the rules and regulations were notified under the Insolvency and Bankruptcy Code to make it operational. Information utility had been licensed, but it had not become fully operational. 3 institutions had become operational as on 1st December 2016, when Insolvency and Bankruptcy Code became operational in the sense that it opened up for cases being filed from 1st December 2016. And from here, I would say, would start the journey of insolvency and bankruptcy code. And it'll be interesting to talk about what it has achieved from 1st December 2016 till today. And, what is it that we have achieved in these
So we'll
years?
dive deep into how the journey of IBC has progressed so far in our next episode.